Good morning and welcome to the General Licensing Panel for the Lake Down Trout Fishery, Heathfield. My name is Councillor Meir. This meeting is being held remotely and is being live streamed via YouTube. The recording of it will be available afterwards on our website. Councillors, officers and speakers are reminded to put their mobile phone on silent if they have one near them. Please mute your microphones and turn off your cameras when not speaking, as this will reduce feedback and background noise and saves bandwidth to prevent loss of connection. If you are a member of the panel, please leave your camera on. I will first do a roll call to check all those who are expected to attend are present. As I say your name, please turn on your microphone and confirm you are connected. First, members of the panel. Councillor Field.
Present.
Councillor Madeley.
Present.
And myself. Joining us today, Andy Eaton, Deputy Legal Services Manager.
Present, Chair.
Mark Randolph, Senior Environmental Health Licensing Officer.
Present, Chair.
The applicants, Jamie Daltrey.
Present, Chair.
And Steve Keegan.
Yes, present.
And the applicants' business partners, Des Murphy.
Present.
And Chris Rule.
Present.
And the counsel for the applicant, Mr. Ranatunga.
Present, sir. Good morning.
Good morning. We have representatives, Robert Banks.
Present, sir.
Ian Franks.
Present. Thank you.
And I will try Dr. Andrew Sikorsky. Dr. Sikorsky, are you with us? No. The Democratic Services Officer, our committee clerk today, is Louise Hollingsworth. The review application will be heard in accordance with the procedure previously issued to all parties. As the matter is a quasi-judicial hearing, we must ensure that all aspects of the hearing will comply with the rules of natural justice and the Human Rights Act. During the hearing, members may wish to ask questions of the applicant or representatives. It is not possible, unless the chairman specifically allows so, for parties to cross-examine each other. All questions need to be made through the chairman. The licensing lawyer will provide any legal direction for members and representatives if necessary before members retire to make our decision. The hearing will be conducted in the following order. First, the licensing officer will introduce the report. There will then be questions of clarification. The applicant or representative will then present the case. There will be questions from members. The representatives present their case, followed by questions from members. The applicant or representative counsel to sum up, and members would then retire to make our decision. And so the first item on the agenda is to appoint a chairman for this panel hearing, and I ask Louise Hollingsworth to take the chair to deal with that first item.
Thank you, Councillor. Could I please have a nomination for chair of this panel, members, please?
Proposed Councillor Meir.
And the seconder?
And I second, please.
Thank you very much, Councillor Meir.
And thank you very much. I don't think there are any apologies for absence. We still don't have Dr. Sikorsky.
No, Dr. Sikorsky is not here.
Disclosure of interest: to receive any disclosure by members of personal interest in matters on the agenda, the nature of any interest, and whether the member regards the interest as prejudicial under the Code of Conduct. Are there any declarations?
None.
No, none. Thank you.
Thank you. Which brings us on to the main business, the report of the Head of Service, Environmental Services, Licensing and Community Safety, the application for a premises licence at the Lake Down Trout Fishery, Swife Lane, Broadoak, Heathfield, East Sussex. And I ask Mr. Randolph, if you would present your report, please.
Thank you, Chair. Good morning. In front of you is a standard licensing report that you'll be familiar with, and it starts off with the introduction. And we're here today because there have been 25 representations made regarding the application. Then we go through the applicant details. Mr. Jamie Daltrey of the Lake Down Trout Fishery. 1.2 is the premises. The proposed licensed premises at the fishery in the Rother district, and just a note there that the entrance in Swife Lane is actually in Wilden district. The report includes a location plan, Appendix B, and then Appendix C is the proposed licence area, which is the existing fishery lodge building. And then there's a site plan there with the lodge marked in a red cross, and the dotted line shows the area the applicant has marked for outdoor consumption. Technically, the applicant doesn't need to show that, they just need to describe it in their application form, which they did, but they've kindly also marked an area on the plan to make it easy for you to consider. Back to the report. The premises is situated at an established fishery in a rural location, accessed via a private track from Swife Lane. The application, section 2, the original application that was submitted on the 25th of January 21, and the details there, the licensable activities are limited to the sale, supply of alcohol, on and off sales, and there's the list of the hours there with reduced hours during the winter months. This was subsequently changed on the 18th of February, and the hours were reduced, and the licensable activity remained the same. That's the sale, supply of alcohol, on and off. But the hours were reduced from Monday to Sunday, 1200 to 2100 hours, and reduced hours in the winter months to 1800 hours. On the next page is the description of the premises. I won't go through that word for word, Chair, but the applicants and the applicant's legal advisor will be expanding on that, I'm sure. The operating schedule. The applicant has described in their operating schedule the steps they intend to take to promote the 4 licensing objectives. These are reproduced in Appendix A1. On the 18th of February, the applicant offered 2 additional conditions. One, there will be a maximum of 1 delivery of alcohol per day, Monday to Friday, 9 AM to 5 PM. And they will be limiting the sale of alcohol to the selling of Lake Down Brewing Company beer, and no spirits will be sold. A potential representation from Sussex Police was withdrawn following the applicant's agreement to the additional conditions which are set out in Appendix A3. They will be familiar to you, and they are the usual CCTV conditions, training authorization, the challenge 25, the requirement for an incident refusal log, and conditions regarding deliveries, online sales, etc. Going back to the report, I included a subsection there headed regulated entertainment because there were a number of objections that mentioned music, and that's a reminder that the government has deregulated many aspects of regulated entertainment. And just to be clear, that the applicant has not applied for any authorization for regulated entertainment. However, no license is required for unamplified live music at any place between 8 and 11 PM if the audience is less than 500. Therefore, the applicant is already entitled to put on performance live music until 11 PM, regardless of this application. Section 3, licensing history. There's no previous premises license history at this premises, and a check of our database, and there are no noise complaints logged regarding the premises either. There were 25 representations received from interested parties, 10 in support of the application, and they are listed in Appendix E1, and 15 in objection to the application, and they're in Appendix E2. Chair, would you like to take it as read that those representation have been considered, or would you like me to go through them?
Well, you could very briefly summarise the main objections, but you can take it that the panel have read the papers.
Yeah, most of them follow the ones in objection follow a similar statements, and they are mainly concerned with public safety and public nuisance, the narrowness of the lane, public safety, nuisance, etc. There were no representations from the responsible authorities. As mentioned earlier, the Sussex Police withdrew their potential representation and the applicant agreed additional conditions. Section 7, just going through the relevant legislation. Section 8, well, again, this will be familiar to you, that the following options are available to the licensing panel in consideration of this application, and that's to grant the licence subject to conditions, to exclude from the scope of the licence any licensable activities, to refuse to specify a person in the licence as a designated premises supervisor, or to reject the application. That ends my introduction to the report. Thank you, Chair.
Thank you. I just one question, and that is, on my introduction, I had Mr. Daltrey and Mr. Keegan both as applicants, and you were saying there's one applicant.
There's only one applicant, Mr. Jamie Daltrey, as an individual.
Thank you. Do other members of the panel have questions? No?
Nothing.
In which case, I ask Mr. Ranatunga, how would you like to proceed? Will you be calling the applicant, or would you wish to simply to address us?
So the way I would envisage addressing you is to introduce the application and explain it and deal with some of the points that have arisen. I will introduce Mr. Daltrey, Jamie Daltrey, and also Mr. Keegan, who, just to be clear, is the designated premises supervisor on the application. So it's Mr. Daltrey who's the applicant, Jamie Daltrey, and Mr. Keegan is the DPS. But I will call on them as necessary. I think I propose to address you in the first instance, and insofar as I need to, I will refer to them, if that's okay.
Yes, that seems absolutely in order. So if you would wish to proceed.
Thanks, sir. And I'm just aware that Mr. Eaton helpfully raised the issue of the further conditions which Mr. Banks has mentioned this morning. I think I'll come to that at the end, if I may. But if I can just introduce this application, as you've heard from your licensing officer, it's an application by Jamie Daltrey, really on behalf of the Lake Down Brewery Company, to enhance what is an established fishing business at Lake Down Farm. And when I say an established business, it's been there and been operating as a fishing business for over 40 years. And just to give you a little bit of a background, I'm sure you may be familiar with it, but the landowner created these lakes. There's 4 lakes within the farm which give rise to trout fishing over 40 years ago, and it's always been and remains and will be the intention of the applicant to preserve the land and its views. It is an AONB, and it's always been the intention, and is and will be, to promote the safe and responsible stewardship of the fishery. It provides for trout fishing, and what we seek and always have had is a good fishing day. But what we seek to do through this application is to enhance that business by the offer of allowing those who fish, and I'll come on to others as well, a beer at the end of the day, effectively. That's the way in which we put the application. It's part of the operation of a fishing business such as trout fishing that noise should be kept to an absolute minimum, and nothing that we propose seeks to undercut that. And so it's right that I set that out as an established business which has been operating for over 40 years. The other point about that is, over the years, there have been up to 100 people who have frequented this fishing business on a daily basis. So it's right to note that in terms of the context of some of the things that have been raised about traffic and footfall and so forth. So one aspect of the application is to enhance that business by allowing for the lodge, which you've seen on your plans next to, I think, Lake 1, to be used by fishermen to as a tap room and to have a beer and to talk over their fishing for the day. But the other aspect is this, which is that Lake Down Brewing Company is situated in Blackboys, like 10 minutes away. And what we envisage and what we seek to do through this application is to allow for the sampling of that local microbrewery beer at the lodge, with a view to, if you like the beer that we offer, you being able to purchase the beer as an off sale and take it away. So those are the two really key aspects to what we propose through this application. And that's why we have an application for both on and off sales from the lodge building and indeed the garden terrace. So you've had Mr. Randolph refer you to that outside area, which is on the photographs you'll see on page 20 of your agenda. 19 and 20 is the lodge we're dealing with, 20 is the outside area, where we hope to have people sit out and enjoy a beer on occasion. As Mr. Randolph has made clear as well, there's no application here. There's no application here for regulated entertainment beyond the sale of alcohol. And he's been very clear in his report and helpfully set out what the Live Music Act says in any event. So what we seek is to operate as a tap room, effectively to support a local craft brewery. This is not a bar or a pub in the sense that you might have in a village. It is a tap room offering locally produced beers which you can sample on site and then purchase to take home. What we envisage is something akin to a vineyard style tasting room. It's a low volume, high quality offer. Low volume, high quality offer. We do not envisage upright drinking. And to that extent, you will have seen the condition that one of the conditions that we propose in addition at the bottom of page 3 of your agendas and the report. We will only be selling Lake Down Brewing Company beer. No spirits will be sold. That's the condition which we offer up. The principle there is that it's Lake Down Brewing Company beer, which is in low volume and high quality. That's how we seek to operate. Now, just a couple of other points in relation to that. Firstly, the location. Well, it's a few hundred metres away from Swife Lane. We say it doesn't have any immediate adjacent residential properties. It's down what is a private track down Lake Down Farm. And then in terms of how the scope of the application is set, so you and your colleagues will have seen the hours that we seek, and it is all commensurate with what we're seeking, which is a 9 o'clock closure for alcohol and opening through the spring and summer months. So April to September, this will close at 9 p.m. And through the autumn and winter, so that's through October to March, it closes at 6 p.m. And that really reflects the type of offer that we're providing, and principally is to do with the fishermen using it during daylight hours. And you can see obviously at the moment what we have in terms of daylight hours. The hours is a restriction. We started off seeking more for the purposes of flexibility. We saw the representations that came in. We've been quite fair, I would suggest, and cut back those hours to reflect the concerns that have been raised by residents. So that's one aspect. The other aspect I want to raise is just these additional conditions. I've made the point about only selling Lake Down Brewery Company beer, but a number of the representations do talk about the single access track and concerns around that. And there's 2 points to make about that. The first is the history of this site is there has been over the years quite frequent access to this site with up to, I understand, 100 people frequenting it on a daily basis at times, which we say has never caused any concerns. But insofar as there is a concern, we're quite happy to offer the condition at the bottom of page 3. There will be a maximum of 1 delivery of alcohol per day, Monday to Friday between 9 and 5. What is envisaged would be a transit van which delivers the alcohol from Black Boys to the site, and we limit ourselves to 1 per day. So those are the 2 conditions, the Lake Down Brewery Company beer, but also the deliveries, plus the hours, are the ways in which we restrict ourselves. That, of course, is in addition to the conditions which we've agreed with the police, and you'll see those on page 9 of your agenda. Firstly, what you might call a standard CCTV condition, a very full one, but we've agreed that with Sussex Police. Then we have training and authorisation, the condition on that, and refresher training, it being fully documented and recorded. Challenge 25, if there were any concerns about underage sales on a site such as this, which is not something that we envisage, but it's there as a condition. An incident and refusal log, that's on page 10. And then there's a wider condition for deliveries, which is overlaid, if you like, with the specific condition which we've set ourselves for 1 delivery per day. So those are the conditions which we've agreed with the police, which has led to the withdrawal of their representation. Can I at this stage just introduce Jamie Daltrey and also Steve Keegan? So Jamie Daltrey is on this call, he's introduced himself. He is a manager, I think, at Lake Down Brewery. And Jamie, I understand, has some experience in the hospitality industry, but also has worked at the farm for a number of years to do with the fishing business, and lives locally in Stonegate. Jamie Daltrey, can I just introduce you on that basis? Is there anything to add to that?
No, that's it. That's how I want.
Thank you. And Jamie Daltrey is the applicant, but as you've heard, sir, the designated premises supervisor is Steve Keegan. He's also on this call. Steve Keegan, if I can just introduce you, I think you have over 20 years experience on and around licensed premises. You were at one point an operations manager at Fuller's, involved with day-to-day operations on a number of sites, but also involved with managing training. And I understand you live in Lewes, is that right?
Yeah, that's right. I've worked in pubs all my life and spent quite a few years with Fuller's in senior management, and ran 11 sites for them before starting my own small pub group where I ran 7 licenses. And yeah, I've got plenty of experience and the upholding of all of the conditions on this license, and the training and the induction of all of the staff who will be running and managing that license will be my responsibility.
So if we just deal with it in this way, please, Steve, thank you for that. Page 9, we've got a training and authorisation condition. We've also got challenge 25 and an instant refusal log. Insofar as those are conditions we're offering, just help me, are those ones that you would be managing and dealing with in terms of delivering the training and setting up the procedures and having the instant book and everything else?
Yes, pretty, as I'm sure people know, it's pretty straightforward, and we have systems that we're going to be putting in place that will manage all of those. So yeah.
Thank you for that. And just so we're clear with Jamie and Steve on the call, Jamie Daltrey, I think you're proposing to do your own personal licence training as soon as circumstances allow, as soon as COVID restrictions are lifted. Is that right?
Yes, that's correct. Yes.
And living in Stonegate, you're very close by. Moving forward, what's envisaged is that you'll be in day-to-day control. Is that right?
That's correct. Yes.
But in any event, we've got Steve there to deliver the training, and he'll be in charge of training and refresher training and so forth moving forward as well.
Yeah. Yes.
Okay, so I hope that's clear in terms of some of the comments that have been raised about experience or lack thereof. The DPS is Steve Keegan for the foreseeable, but if matters change, we'll be raising it through the appropriate avenues. But obviously, Jamie Daltrey is local as well. And just on that, Jamie Daltrey, obviously we've had representations from residents. I'll come on to that in a moment. But in terms of keeping contact with them, are you prepared to offer a mobile phone number for any resident to contact you?
Yes. of course. I'll make the mobile freely available to anyone that needs to get in touch.
I'm grateful. Well, that brings me to how we've dealt with the application, which is a couple of weeks ago, having received the representations and considered them, and having cut back the hours in any event, we did seek to approach residents as best we could to discuss. I think we spoke to 2 principal residents and got them to speak to others. And we did, I think, visit some residents as well. And as of, I think, Monday last week, we managed to have a meeting with 7 residents, socially distanced, COVID restrictions compliant, I should emphasise, outdoors at the site, where we discussed the application, discussed any concerns they had, and were there really to help residents to understand what this application is about, having seen what they had to say. And we're pleased actually to see that that has led to, I think, the withdrawal of 7 representations, which I'm aware of, from those that were originally submitted, which is why I think the original agenda said 21 representations against, and it's now 15. I believe it's 7, but one way or another, we still see that some people have concerns, but that's something that we've put through as the partnership approach to licensing. So I know that you've seen and will have considered the representations. Can I just at this stage emphasise those who've written in support, because those are still about the licensing objectives. It's never a case of how many for and how many against, and what relevance does that have, as you'll know, Chair, and your colleagues. But absolutely, it's right to note this. Some of those who've written in support have been living and or working in the area. I think one's for 60 years, one for 70 years. 2 of them, one runs a holiday cottage and one has farmed the land, so they are actively involved in businesses in the area. You'll have seen on page 22 one of the fishermen and actually an angler on page 28, people who actually use this site for fishing, and their support for Jamie Daltrey and the business and the way it's run and the intentions behind this application, and really what they seek to use of it. So these are people I'd ask you to note in terms of those in support who are long-standing. They've been involved in and around the area for some time, and they are fully in support of this application. As to those who've withdrawn, I'd also just note this. We did have a representation of Julie Upton, who is just beyond the entrance exit to Lake Down Fishery, and also the Gastons, Mr. and Mrs. Gaston, who are opposite the entrance. Those are some of the nearest neighbours to this application who, having discussed and considered with us, have decided to withdraw their representations. So that's not to say we don't hear what residents say and we take what they say seriously, but I do want you to note those who are in support and what they have said in terms of the content, as well as those who've withdrawn. Now, I'll just check if there's anything else at this stage, because I'm aware, sir, that I'm allowed a summing up as well. Is that right?
Yes, you are.
I'm grateful. I think I'll just raise this, of course. At this stage, I'd just like to say that the way the Act works, you and your colleagues will be well familiar, is it's essentially permissive, in that the flexibility around the Act allows applicants to apply for such licences in the knowledge that the Act itself has key protections, one of which is the ability to review a licence, and on a review, the ultimate sanction, as you and your colleagues will be well familiar, is that you can revoke a licence. It's permissive to that extent. And what we note first and foremost on this application is there are no relevant representations from the expert bodies, by which I mean the responsible authorities, all of whom have been consulted on this application in the normal way. The police have withdrawn. Environmental health on noise, for example, planning issues that have been raised. None of those responsible authorities, the experts in the area, have any relevant representations to make. And so we hear what residents say, and I know there's 2 here today. We have sought to discuss with them. We've offered the conditions, and I suppose just to flag on conditions, the last thing I'll mention, sir, because I'm aware of the time, is the conditions which we offer, and so that you and your colleagues can seek to impose, are obviously those which are appropriate and, importantly, proportionate. And it's proportionate on a new application. What is it proportionate to do? This is not a late night bar in a town. This is an offer which is really to enhance an existing business through a lodge in a rural location. And we say that those conditions that we've offered are proportionate. We should not, is my respectful submission, be looking to over-regulate licensed premises, because if you do, you can stifle a business. And what you know, sir, is that any one resident in the future, if concerns that are, we say, really fears, which we hope we've allayed, if those come to fruition, if there are problems here, then of course we would seek to deal with them in the first instance when they're raised. But insofar as that can't be dealt with, you, sir, have the key protection of the review mechanism under the Act, whereby we can be brought back before you and you can impose such conditions as you see fit, and ultimately revoke the licence if you're not satisfied. So with that, fine, I just turn to the conditions of Mr. Banks. It is regrettable, actually, that we've only just received those,
yes,
because
we on the panel have not seen those yet.
Yes, and I know Mr. Eaton, I've discussed this with Mr. Eaton, and Mr. Eaton will know Regulation 18 of the 2005 regulations for the boring lawyer's point, which is that conditions which are, documents which are raised at the hearing, which this is, can only be offered with the consent of the parties. And I have discussed this with my client and advised them of what the law is. And the reason that's there is because we shouldn't have to deal with these on the hoof, frankly. But they've taken a very reasonable view, and we have looked at them in the time we've been given, and we're not going to object on that basis to this document coming in. As to the conditions on this list, though, that's a very different matter. We've gone through them. I would say condition 1 about life preservers. We're quite happy to have a condition requiring us to have life preservers available. It's something we've discussed and we're going to have anyway.
It was referred to in the report, yes.
Yeah, and so there's no concern with that. And condition 10, which is about setting up a group. I mean, we're quite happy to set up a WhatsApp group, as is the modern way, or some sort of way of communicating. I've already mentioned that Jamie Dockery will provide his mobile number, but condition 10 as proposed is for us to set up really a group which neighbours can join and be able to raise issues with us, called once a year. And we're quite happy to have a condition along those lines. That's no issue with us. As to the rest of the conditions, so we're not prepared to accept those as conditions. I mean, there's a challenge 26 young person policy. Well, it's challenge 25 that is the industry standard, which is a condition, I should note. It is a condition on this. And so we don't need that. There's nothing that the fire safety responsible authority is raising in relation to capacity, and we shouldn't be seeking to duplicate other legislation in that respect. I can deal with 4 and 5 when they're raised. Risk assessment is something that we do anyway. The hours deal with the last orders point. We're not looking for a time-limited application. The way these things work is you get your license, but it's subject to review. We're not seeking to have wedding events or music events, and your officers have advised you on the Live Music Act. And the AOMB point, so we are very aware of light pollution and the concerns raised. And as I've always said, we're here to preserve the land and its views. Any lighting as is necessary would be low level and downward facing and will not lead to an issue. Your environmental health officers have not raised a concern about that, neither have planning. And so we don't accept that a condition along those lines is necessary or proportionate. So that's just a quick overview in the time we've had available. But 1 and 10 to accept, probably 10 in a slightly varied wording, but we'd be prepared to set up a group for discussion with residents on an annual basis. Thanks, that's everything I have to say.
Yes, thank you. We'll have to think about whether we should see these 10 conditions. I imagine that we probably should, or proposed conditions. But I think the next step probably would be for members of the panel to ask you some questions, Mr. Ranatunga. I think they're sitting there with bated breath. Councillor Field.
Yes, thank you. You talked about sales of beer and said you'd be confining it just to the one brewery and no spirits. What about wine? Do you plan to? Because there are many local vineyards around as well who might have the same wish.
Yes, it's a brewery and it's beer, is my understanding. I'll look to Jamie Daltrey as applicant if is there any intention to sell wine?
No intention to sell wine. We just want to sell products from our own brewery.
Thank you.
I think for the sake of completeness, Councillor Field, I would say I think that non-alcoholic beer is something that we will be seeking to sell, but it's non-alcoholic. So that wouldn't be covered by the condition and wouldn't be covered by that restriction. But I just raised that for the sake of completeness.
Thank you.
And would you accept a condition that there should always be non-alcoholic drinks available as well as alcoholic ones?
I'll look to Mr. Daltrey. I'm seeing a nod. There will always be soft drinks, I understand. But is that the intention? We can have a condition that there'll always be non-alcoholic beverages available as well.
Yeah, that sounds reasonable. Yeah.
So yes.
Yeah.
Councillor Madeley, do you have any questions?
Yes, Chair. Thank you. My my hand has finally gone up. It wasn't specifically mentioned by Mr. Ranatunga, but it has been mentioned within the documentation. How are your clients going to deal with the dispersal of customers, please?
Well, I think the first point to make on that is the type of operation we're envisaging is not one where everyone's in until lockout and then everyone's kicked out. It's not that sort of operation. But insofar as that is a concern, it is something that we would seek to have, by reference to the hours, we would have some sort of dispersal approach. I'm going to look to Steve Keegan on this. There's no music offer, of course. It's simply the tap room for fishermen and those who want to sample and purchase beer. But insofar as there's any concern about that, just help me with this, Jamie and Daltrey and Steve Keegan. It's not envisaged that we'll have significant footfall, is that right, from passing trade or anything like that, like a pub? Is that right?
Yeah,
We don't envisage that.
Yeah, very true. One of the reasons that during the summertime that we've asked for a little bit of a later license on that is to aid with dispersal rather than everybody leaving at the same time. We will have signs on the exit of the venue asking people to respect the neighbours that we have and also to keep noise to a minimum when leaving.
So we'd be quite happy to have some signage. We would have some signage up on that. I mean, Steve, you will know from your experience and dispersal policies how those work in terms of winding down.
Yes, as the venue is definitely a destination, it's not an area that people will walk to and from. We envisage a lot more of a more sporadic amount of people coming to us rather than as a traditional pub would be, people getting in there at a certain time and leaving at lockdown. This is definitely more of a tasting room for people to come and enjoy. You know, there will be booking elements to it that we will take on as well that will aid. But in the nature of a vineyard tasting space, it will not operate like a usual pub where everybody leaves at a certain time and then you get a large dispersal of people.
Can
I
I
think
also,
just to mention one point on that is obviously the condition is only to sell Lake Down Brewing Company beer, which is low volume, high quality. So the nature of the operation is not the same as, if you like, Heineken are in the town.
can I also add that the nature of fishing means that fishermen don't stay until the end of the day if they caught their fish. They'll be dispersed throughout the day as well as they can catch the fish after.
Thank you. Somebody, I think, has their microphone switched on. I'm getting a certain amount of background noise.
Sorry, it might be me.
I think that might be better. Yes. Councillor Field.
Thank you. Yes, I just wanted to pursue, if I could, this issue of dispersal, because clearly you're very used to running a fishing operation and you know how fishing people come and go. But if you're offering off sales and tastings to people who aren't fishing, then I just wondered what your background research had been to ascertain the level of people who will come for that purpose.
I think I'll ask Jamie Daltrey to come in after the fishing business, but I think the point, I hope it wasn't lost in the noise in the background from my microphone, which is that the way the fishermen work is once they've caught their fish, they don't want to hang around, they want to leave. And Councillor Field, I can see you get that point. I don't understand, I mean, that's one aspect, a very clear aspect which people have written in and support about. What you've also heard is it's not envisaged that we would seek a significant footfall just from passing trade. I think what Steve has mentioned is some of it, and I have to be clear, only be some of it, might be by booking or appointments, and that will be to sample and then purchase. But it's right, so there will be an element of you can come and sit out and have a drink. But really, if one looks at the size of the premises and also what's envisaged in terms of the different elements to it, when you add to it what is being offered, which is low volume, high quality beer, we say that that is sufficient really to regulate dispersal.
Sorry, we're losing the sound again, Mr. Ranatunga.
I'm sorry. I don't know. I need.
Jamie, it's your microphone. Jamie, can you go on mute, Jamie? There we go.
Yeah.
Yeah. So I think with the way, in which the application is set and what's envisaged, it's not really. It shouldn't be an issue where there is a dispersal concern. If and insofar as in the future it transpires there's a problem, then that is something that can be revisited. And it would be revisited in this way, wouldn't it? We would have our meeting with the residents would raise it, and we would regulate ourselves. But if that's not sufficient for the council, we'll be back before you, and you will be imposing that condition.
Thank you.
Thank you. I have a question. I see many of the objections concern the capacity of Swathi Lane and the track to accommodate the additional traffic. If you are to have passing trade, and at the moment there would be nothing to stop you encouraging passing trade, though you say you don't anticipate very much. I mean, is there any way in which the numbers could be kept to an acceptable level? Bearing in mind that is a very narrow lane indeed.
Well, I think what we've committed to, sir, is about the deliveries, which is about vans and transit vans. Insofar as there's additional traffic to that, and that might be from people who have bookings, that might be potentially from passing trade. We have capacity on site for the parking. That's the point that's been made in the application. But above that, it is a single access track in a rural location, along with a number of other businesses. We've sort of done a bit of rooting around on that, and I'm just going to reel off a few names on that. Bunsen Brothers Agricultural in Blackboys, Bluebell Winery in the old dairy farm shop in Spider Lane, Uxfield, Bedgebury Pine Eaton in Goudhurst, Authentic Reclamation. Those are all in Stonegate. Those are all examples of businesses which we understand are actually far busier than this one was and is, which are all down single lane access tracks. I'll ask Jamie and Steve to deal with that as necessary. But we wouldn't be unique, putting it that way, in having a single access track business, which you have in a number of other areas here, which are busier. Now, the other point to note, which I have emphasised, but I do mention again, is this was a fishing business which had up to 100 people visiting it per day in the past, and I'm talking about 10, 20 years ago. But it has been busy as a fishing business itself, and that's not caused problems. And so we certainly see what residents have as concerns, but it's not something that's been raised by planning or environmental health, who are the experts, and we have the capacity for parking. And the history is that it's been much busier than this, and there's other businesses which are far busier than this down single access tracks.
Yes. I suppose
Also,
sorry, if I could just say, what you say, I suppose, applies to Swaith Lane itself, not just the track. It has worked thus far. You say, no doubt we may hear to the contrary. So far as the highways is concerned, of course, the highways are not a consultee on this particular type of application, so we've not actually heard one way or the other from highways. I just put that to you in case you have any observation.
Yes, I accept that, sir. Highways are not a consultee. Planning, though, insofar as parking provision and the availability of it, do, on occasion, I accept it's not strictly their remit, they do mention those sorts of issues if it's a concern. What we say is the history has not shown there to be a problem. And with COVID, we know in the last year, particularly with deliveries from vans, there's been an increase overall in deliveries from DHL and Amazon and supermarkets and everyone else. That has not, I mean, one of the supporters actually specifically mentions this, page 24. There's been an obvious increase in that, which has not caused problems. And we're looking at an additional transit ban for deliveries and some, potentially, some passing trade or bookings for which we have parking provision on site. So I think that's how that's what we'd say on that, sir.
Thank you. Do councillors have any more questions? No. Thank you very much. I wonder if this would be a convenient moment to adjourn for 15 minutes or so. Should Mr. Eaton might advise us, should we see these proposed conditions at this stage?
Sure. Certainly Regulation 18 says clearly that on the day of a hearing, no new material can be introduced without the consent of all parties. And that was the reason why initially I gave council an opportunity to have a look, because obviously if he didn't consent to it, then there would be an issue for you to consider. He has accepted that he consents to the document being provided, and he has addressed you on what he says are his views in relation to the itemised conditions which are on there. It will be for Mr. Banks to address you on those conditions. He can only set out conditions he believes should be there. It's for you to consider when you deliberate on this particular application, whether or not A, you're going to grant the licence, and B, if you're going to grant the licence, whether or not you feel any condition is appropriate. And at that point, you'll be then considering the conditions which have been proposed both by the applicant and by the representatives as well. So at this stage, you don't necessarily need to see them. You will be addressed about them by Mr. Banks.
By Mr. Banks,
yeah.
Very, very shortly, no doubt.
Yes.
Yes. Well, in that case, perhaps we might adjourn for 10 minutes instead of 15. And then we will proceed, unless, Mr. Anatunga, you have anything further to add. At this stage, we would proceed to the representatives. Can I ask, Louise, do we have Dr. Sikorsky yet?
No, we don't, Chair.
No. Well, thank you. In that case, we will adjourn until 11:10. Good morning. This is a continuation of the Lake Down trout fishery application for a license, and we have now reached the point where we can hear from the representatives, and I would call firstly Mr. Banks, please. Mr. Banks, would you like to address us?
Well, thank you very much for the opportunity. I wonder if I could first of all give you some information and then make a request to ask some questions of the applicant or the applicant's solicitor, as Mr. Jamie thinks, or maybe he's a counsel, I don't know. I do have some questions for them, but I appreciate you don't, this is mediation and not adversarial. But yes. There are matters which were given by the applicant's representative that don't appear correct, and it would be probably better if you heard him being able to deal with those inaccuracies, but that would of course be with your leave.
Well, shall we hear your representations first and take it from there?
Yes. Well, can I say to start with that it is very much to be regretted that when I put in my objections at the beginning, rather dismissed them as being not relevant, which had the effect that I had to seek legal advice, rather had to receive a solicitor's letter, and they accepted, in essence, they were all reasonable grounds, and that meant that it put me in a very difficult position, being involved in this hearing at the very last minute. And it was only yesterday that I was able to see Jamie, and I must thank him for his hospitality and his frankness in what he said. But that is the reason why you're getting the suggested conditions at this late stage, because of Rother's legal department misinterpreting the rules and put you and me in a difficult position. And I think it would be helpful to you, to your counsellors, to know that I'm not throwing documents at the last moment.
Well, thank you. If you would address us now on your objections, please.
Yes. Yesterday, I had decided that, having talked to Jamie, that this was an appropriate one, a case in which the application could be granted subject to conditions. And the reason primarily why objections and conditions were suggested was because there is an unknown factor to this. There's something that doesn't quite add up about this application. And having listened to the representative for Jamie, there's really no meeting ground. He just wants it on his own terms. And there is areas of disquiet, which I had hoped could be resolved by the conditions. But the dismissal by the representative of having conditions to overcome those fears mean I've gone from the beginning of this hearing to being one that I feel that the problems can be overcome, to now, with not being able to get more detail from the other side, I have to continue with my concerns so that you are able either to refuse it or to substitute suitable conditions, in which I say that the conditions that are suggested really fail to deal with the issues in any proper way. And it might be helpful if I go back to the areas of concern, but not seeing it in the applicant's way as, oh, everything's fine, oh, don't worry, but the reality on the ground. And the reality on the ground is that there was no consultation to this meeting, and there were all sorts of stories going around about what was going to happen.
No consultation for which meeting?
There was no consultation for the application. They just made an application, and it was for very long hours. And the obvious thing is, well, what is going to happen to the neighbours? And my perspective is also concern for the neighbours, but what is going to happen to the AONOB? Is that going to be protected or not? And the safety of people going there? Well, it would have all been manageable, but because some of these conditions are not accepted, then we have a problem. And perhaps the key one is that originally, as you will see from Schedule A2, that the applicant, if it's Appendix A1, the applicant in Schedule Appendix A1D, which I'd ask the IT person to be able to put up on the screen, with your leave.
I have it in front of me on paper, but can that be put up on the screen? And can we screen share that? But we do, councillors do have the papers. And
of course they do, but it makes it easier for people to follow, perhaps. But it's a matter for you, sir.
It's a question of whether it's technically possible.
Well, I'll continue while it comes up. Now, there in the conditions, they're offering that the event should be limited to 50 people. And this is a commitment to RODA. But they've decided in the last few minutes that that one is not going to be put forward. And that's rather worrying. Why is that? And the background is to that, as I understand it, the fishing is limited to 25 people. And so the restriction of the numbers to 50 makes a lot of sense, their original position. But why is it now? And that is one of the conditions that I put down as being agreed by the applicant. But they're not going to have it now. They want it unlimited. So that is concern one. But instead of having it as the story goes, in the space of this hearing, it has now become an open-ended event, a danger to the neighbours, with no limit, although one was offered and agreed. That is my concern, and I would invite you to say that if there are only going to be 25 fishermen, there should be the opportunity, there should be a condition to limit it because of the real problems in relation to this site. Now, can I also say, in relation to this matter, that my concern is the protection of the A&OB and also the neighbours. And the neighbours have written in clearly about their concerns, which need amplification. Now, in relation to the A&OB, this is the absolute epicentre of one of the most beautiful villages in one of the most important. There we are. Do you see?
Which one are you drawing our attention to?
Well, it's been renumbered in the report that I was given, dated the 30th of March. I have the one that Appendix A1 in D, my copy says numbers will be limited to 50 people. Yes, there it is, D. Now, that has been taken off the table, this proposed condition. So why? So can I go back to the A&OB and perhaps now everybody's read it?
I don't. Can I just ask council whether that is still in the operating schedule or not? Might just short circuit things, perhaps. Is the limit of 50 people still there?
What it says is this: numbers will be limited to 50 people owing to car parking space. It references is, as I've said, there is a car parking provision on the site which limits to 50 vehicles, I think. But the point that's being made is there's a sort of extent to which it's regulated by that. Now, what Mr. Banks is talking about is imposing a condition over and above that, for which it needs to be appropriate and proportionate. And we say it's not appropriate and proportionate to do that with everything else that's in place.
Thank you. I understand. So now, please continue.
Well, Mr. Chairman, can I deal with that? It's I'm rather unhappy if I can't answer any questions of the other side, but they can chime in during it. But of course, I appreciate I'm being given the fullest opportunity afterwards. The normal interpretation of the phrase "numbers will be limited to 50 people owing to car parking space." Owing to car parking space is the reason, and therefore this was a commitment, and whatever the legal representatives say that is a condition that has been offered, and what he says about it cannot reduce that commitment, because that is the plain Brutus versus Cousins interpretation of that condition. And I'd invite you to say that the explanation it's to do with the car parking doesn't deal with the point that the numbers at the premises, which is the only way numbers can be read, will be limited to 50 people. And it makes sense because there is a limit to 25. So if he now wants to increase it to however many we like, then it's not really, as the narrative began at the beginning, which was that this is for a nice place for people after their fishing to go and unwind. Well, some of them will have gone home by then. But they and those 25 people are suddenly going to be increased to any limited, with no limit. And so that is an area which I would invite you to look at most carefully and consider that the condition that was offered, plainly offered, and not in any way undermined by what has just been said, should be made a condition. And can I now give you the explanation for that? And it might be helpful if the IT person can put up the map, if that's a quick operation. If not, I'll carry on. Here we are. Now, do you see the arrow in the middle? And if you go to the left, do you see you go to Swife Lane, right?
Yes. Yes.
And there, if you go down Slife Lane, the whole of that is single carriageway. And if you go down to the bottom, it becomes, you then have this triangle, part of which is on the map and part of which isn't, and that's single carriageway. And if you then go to the corner of a triangle and you then go to the A265, that is all single carriageway. And if you go up the other end, if you go beyond where it says Swife Lane, I haven't been there recently, but I would put a lot of money on that that is all single carriageway. So we have the most troubled access to this site, which is why the numbers do need to be limited in the way that they'd originally said. And as far as the numbers are concerned, the representative, if you don't mind me saying, says with quite a flourish, he says, it's not caused any problems. Well, I'd invite you to ask, who are we to believe, the neighbours who live there, or someone who's trying to diminish a problem in relation to this access? Because this is an area that has tremendous problems, and it's an area of great importance. And in terms of the A and OB, and the neighbours, it said it's not caused any problems. Well, the reality is, if you read the objections, it's caused a great deal of problems. And if you think of the amount of people who would now go to this unlimited numbers place, there it would be a great problem with the road Swife Lane itself. And Swife Lane is quite a complicated description, but it covers all the area on its own. And can I now go to the site? Now, if you've got the arrow, if you then go up to the right angle bend, that is single carriageway, and it's single carriageway almost, I think, I'll be corrected by Jamie if I'm wrong, it's single carriageway up to the red house. Oh, yes, thank you. Up to what was a red house. And when Jamie very kindly let me have the opportunity to see this beautiful, stunning place, if you could then go back a bit, if you could go back to where you were, please. Thank you. I was driving right round to just near the wood, and I met a farm vehicle with a trailer, and I had to reverse all the way back to virtually the corner. And that's quite a way to reverse. And this is on a day that it's not operating. So this road, the access to this site certainly does need limitations, because it would be utterly chaotic if you have a large number of people going on this single track road. And I would say that that condition which was operated should be there. Now, in relation to challenge 26, that was a typo that I did this one. It is challenge 25. They say they don't want that as a condition, but that is a condition that's already been operated, already been agreed.
No, Mr.
So
Banks,
you wonder why they're...
Mr. Banks, sorry, no, they've accepted challenge 25. They accepted it because the police had offered it, so it is on offer.
It is on offer, but the way that the 26 was dismissed, well, if you accept the typo, then that is in agreement. Now, as far as the conditions that were on being suggested, the extra conditions about the delivery, this would be on the side that I would say that this is one of the few conditions that in fact might stifle the business, which is the reason why the representative didn't want conditions. The condition that's offered about one delivery, if you're going to have hundreds of cars or 50s of cars, the extra delivery is going to make no importance whatsoever. And I would say that to help Jamie, that condition that's offered, do you see there under A2, wouldn't help the business at all, and wouldn't help the A&OB, and wouldn't help the traffic at all. So I would say that's unnecessary, but they won't have it. And in my condition 5, I wonder if perhaps with your leave, I could turn off my microphone.
Chair, do you want to move to Mr. Franks? I think
I'm very sorry about that. I've now got rid of the phone, and I wonder, Mr. Chairman, whether now that it's been referred to, that your colleagues and the other members here could see my conditions.
Well, Mr. Banks, you're supposed to be explaining the conditions.
Yes, but it's easier to explain it if they're on the screen.
I would prefer you to go through them one by one and explain why they're necessary.
Okay. Now, my condition about the restriction in relation to beer, I suggested that this would be appropriate, that the license should permit wine, because I don't think an all beer premises is suitable, because it may turn into a sort of all male thing. And if women were encouraged to go to this place with wine, I think that might help the balance of this item. So I would say the stifling the business, which is concern of the conditions that I suppose, applies to the supplementary condition that the legal representative is advocating for just selling one particular type of beer. And therefore, I would share the concerns of your colleague who thought that it would be suitable if it was extended to wine, and if they don't want to do it, that's fine, but it means they wouldn't have to come back to you. Moving on to my next condition, the next condition was that there should be a risk assessment, and it should be drafted and the recommendations applied, particularly of the risk of people in the dark going into or falling into the lakes. There's a large number of lakes, and that is not wanted because it's stifling business and we do it anyway. This has a particular problem with the lakes, and I can see if they're not doing it, if they're doing it anyway, that there would be no problem with having a condition to tell them they've got to do it. But it raises the question, if they're doing it, why don't they want a condition? And this raises the extra concerns in relation to the place. Can I move to one of the major concerns of this application is that they're saying it's just for people to have a beer after fishing, which I've been told by Jamie helpfully finishes at dusk. Well, it can't be turned into a pub. That would be not in line with what they say, and it wouldn't be in line, I suspect, what you and your colleagues think is appropriate. So we've been told by the representative this isn't going to be a late night bar. But it does raise the question, well, what is it for? If it's for the odd fisherman to come and take the beer afterwards, tomorrow when we go into April, the sun will set at 5:20. But they are asking for the place to open until 10 a.m.
9 p.m. I think.
I think it's 10 in the report I saw, 10 a.m. and 11 in the weekends, unless it's been pared back to 9 and 10. But in any event, that's a long time between 5:20 and when the place will close. So the idea that this is going to be just for the odd fisherman, it looks as if it's a backdoor to have a premises of which we only have their promises of what's going to happen. And those promises I would be prepared to accept, but not now the legal representative has decided not to put any of the conditions. It's just as they want.
I'm sorry, what is the problem with serving beer during the day from the point of view of the licensing objective?
None at all. It's how long it lasts after dusk that's the problem. So if the sun sets at 5:20, the premises will still be going at 10 a.m. So we've got a long time. Yes, Mark Randolph is trying to raise his hand.
Yeah, Mr. Randolph, please help us.
Yeah, Chair, it can't be a public house like a pub because they haven't paid the required fee. So it's an additional fee to become a premises like a pub. So that stops them becoming a pub because they haven't paid the required fee and stated that on the application. So that would be dealt with quite swiftly if it was.
Well, the problem with that is, of course, when they if they get an application for liquor and they're deciding not to add any appropriate conditions, they would be then well equipped to say, well, actually, it's going terribly well. It's only going to be a few select people. So will you now please give us the opportunity to serve food? If they were accepting the conditions, it would be different. But they're just wanting the blank check without any safeguards. And so Mr. Randolph's point, the suggestion he was head up is one that I'd invite you to look at very carefully, and one that would not protect the residents in relation to the step-by-step approach to get something quite different. Now, can I go back to the road? And in relation to the road, it's important to remember that they relied on these businesses which were in single-track roads. But those single-track roads and those businesses, I think only one, but I could be wrong, but practically one or less is actually in Swipe Lane, and they have very different access. So that was a point that was unworthy in this case, if the council doesn't mind, because throwing these businesses that happen to be in Stonegate, who may be on single track for part of it, doesn't alter the very long single track that we've got here, of which they can do nothing about, and which has been explained away by saying, oh, well, we haven't had any problems in the past, but the neighbours say differently. And also, if there's the reason why I was happy to accept this licence was because I thought if they reduced the numbers, the problem with the road would go away. But on the contrary, during these hearings, that protection has gone. So the suggestion I put forward in the conditions was that the last orders should be will be at lighting. Last orders will be at lighting up time. I'd be quite happy if that was extended by an hour, but it must relate to it must relate to the time when people stop fishing. And if it's going to be 5 or so hours afterwards, what you're doing is you are having this late night premises, which has completely unprotected, of which there would be it would be completely unprotected, and the neighbours would be exposed to the noise that would be generated. Now, the next issue is in relation to what council said, is that it's a well-established business. Well, it was registered in September the 20th of last year. The fishing is well registered, but the company, looking at the documents, that company was registered in September of last year. It has no VA accounts, no company history, nothing. Now, that was a concern. I was prepared, if they were agreed to a short period of a year, to see whether Jamie would be able to honour your trust, and I gave him my trust yesterday. I was quite happy for him to have it, but not now, that we should have a year, and then we could see how he got on. But the way the case is now being presented by council, which is very different, is one that that concern has not gone away, and unless there are conditions to deal with that, I would invite you to say, come back when your house is in order.
Can I just ask Mr. Banks, and Mr. Daltrey can help as well, how long has Mr. Daltrey been running this business, whether under whatever legal umbrella, but how long in practice has he been running it?
Are we asking about the fishery business?
The fishery business.
I've been working on Holmshurst Estates for 3 years. I've been running the fishery for just over 2 years.
2 years. Thank you very much. Mr. Banks, please continue.
Yes, but this is a business which has not much experience of running it. They say in hospitality, but no details were given, and that is why I thought a year. But the legal representative won't have it. He wants the full period of time. And I think it would be important for these. I think it would be important for these this applicant to be able to work with the neighbours within the year period, and then it can see what has happened and it comes back. But once he's got his blank cheque, which is what council wants for reasons which have not been fully explained, we have all the dangers that were thought to have been mitigated.
Mr. Banks, I think Mr. Ranatuga wishes to say something. Mr. Ranatuga.
So it's only, I hesitate to interrupt, but it's only to raise this. Of course, we very fairly have allowed this document to come in. We've not objected to it, and we've done our best with it. But I am just mindful of where we are on the time. It's an equal maximum amount of time that's provided to all parties at this hearing. I believe we may have been just over 15 minutes, but Mr. Banks has now been, I believe, we started back at 10 past. It's been half an hour or 25 minutes or so. I am slightly concerned about that, plus this. If you look at Mr. Banks's representation, he was limited to 2 paragraphs, one on the prevention of crime and experience and the other on public safety. He is entitled to expand upon that. And of course, we're happy to hear what he has to say. But I'm just flagging those 2 points because we've now been going about 25 minutes.
Yes, and of course, Mr. Ranatuga, you will be able to address us at the end, so you will have a further opportunity to address us. But yes, Mr. Banks.
Yes.
Do stick to the.
So I would thank you very much, Councillor. I would say that a 12-month period would be very helpful if you're minded to grant it, or the alternative is for them to put their house in order because the sounds are shifting all over the place. They do accept the group, and I think this would be very helpful. And I would invite you to accept, if you want conditions, to accept that condition of the group, because the whole reason why we're here today is because of poor communications and misinformation that's been flying around. Now, can I now move to the dark skies policy? Well, Councillor Meyer, you know more than anybody else about the importance that is now attached to the dark skies policy. It is in the high wheeled design guide as a requirement. And shortly, the neighbourhood plan for Burwash will include the dark skies policy, and this applicant now doesn't want to apply to it. So what is going on? This is the epicentre of the AONAB, and They should be complying with these things. It would be good if it was in the conditions, because it would mean neighbours would not have. We want to reduce noise pollution, but we also want to reduce light pollution. But council is not prepared to have it, and I would say it's essential. Is that what is one of the great issues?
Yes, you Mr. Banks,
parishes.
You made quite rightly made your point on that, and I do take cognizance that there is a lot of public interest and indeed policy surrounding dark skies. So I think we can take that on board and move on to the next point.
Right. So it is for those reasons that I would invite you to say that if they're not prepared to have the conditions, they should be imposed, and if they are. But if you're unhappy about the road, which you have every reason to be, it's essential that it is limited. But if you're not prepared to limit the road, it would mean that the application should be refused. And can I say, in relation to Jamie, through the chair, I'm very sorry to find myself in this position, because I'd come here today to support his application. But the way it's been presented, it means that my support has been cut away because the concerns have not been met. And a realistic balance between the neighbours and the applicant has been undermined by their representative, which means that it puts you in a very difficult position. And I'd invite you just to remember one final thing. The objection is to stifle business. That is not proper. Your concern is the protection of the public, whether they be in a vehicle, by the roadside, or wherever. And I would invite you to ask for my conditions, consider the representations, and consider, most importantly, the way that the safety in relation to the application has been undermined by the way it's presented. Those are my submissions, and I hope they're helpful.
Thank you very much, Mr. Banks. Mr. Ranatunga, did you wish to say anything? Just purely in questions of corrections or anything that you would like Mr. Banks to answer.
There's no questions I have for Mr. Banks, so I'm aware that this is an informal hearing and I have an opportunity to sum up, which I will.
You certainly will have a chance to sum up. So we then have Mr. Franks. Mr. Franks.
I don't have anything to add, actually. One point that was raised actually about the wine. I mean, I think men, women, everybody drinks beer. I don't see a major issue in just having beer. But wine would be a nice to have, but not. I wouldn't have thought it's a big issue that the ladies need a glass of wine. I don't have anything to add, no.
Well, thank you very much indeed. Thank you, Mr. Franks, for coming. And I'm assuming perhaps that we still don't have Dr. Sikorsky.
No, that's right, Chairman. He's not joined. I've not been able to get hold of him, I'm afraid.
So that's a shame. So yes, I think we're now at the point, Mr. Ranatunga, where you can address us further.
Excuse me, Chair, could I just clarify something?
Certainly.
When I asked the question about wine, I wasn't offering it as a condition or a change in the application or anything else anybody might second guess I was thinking. I was merely trying to clarify exactly what was going to be sold, because the application talks about beer and spirits, and we know that people of both sexes drink both wine and beer. I just wanted to be clear. Thank you.
Thank you. And Mr. Ranatunga, you will address us, and I think perhaps one of the things on which you might address us is the question of water safety, which I know is in the paperwork, but that's a matter we didn't cover earlier. You might wish to cover that now.
Thanks, Ed. If I could just deal with that point first, then we've agreed to the condition 1 about the life preservers that Mr. Banks offers up. It's also the case that this has been consulted upon by fire and fire safety. They've sent us quite a lengthy letter about their own regulatory systems and inspections and what they can do and what they may seek to do. And we're fully on board with complying with any fire safety features which are necessary. Beyond that, you've got the photos, so and you've seen the site to that extent. I have Jamie Daltrey here who works there. Insofar as there's concerns about water and safety are concerned, of course, unaccompanied minors won't be on this site because that's the way the licensing works. So insofar as there are children on site, they will have an adult with them and supervising them. That's not that's a matter of law. That's not something that you condition. But it's not, and also it's not something that's ever been a problem. Obviously, it's been a fishing business previously, and this proposes an enhanced business in that sense. So it's not something that we're offering any specific condition on, because no responsible authority has sought that. We don't feel there will be an issue. We're prepared to accept the life preservers, and to that extent we feel that that's what's appropriate at the current time. So I hope that's enough of an answer. If you still have a concern, I can ask Jamie Daltrey and or Steve Keegan if there's other things that we can look at, but I don't think there is at this stage, because we'd want to work with responsible authorities to do that, and Fire have their own way of dealing with matters.
Thank you. Mr. Banks has his hand up. It would have to be very short and very pertinent, Mr. Banks.
Yes, it's in relation to the water safety. The condition that they did not want and reject is a risk assessment. A visitor risk assessment should be drafted, and the recommendations applied, particularly of the risk of people in the dark going into or falling into the lakes in mind. Yes. And that was one of the conditions they didn't have. They wouldn't have, and I think that's very worrying.
Thank you. I'd like to hear from
I hope it's succinct enough.
Thank you. I'd like to hear from Mr. Randolph. I think you had your hand up, Mr. Randolph.
Thank you, Chair. Regards water safety, regardless of whether alcohol is sold or not, I would say that a sufficient and adequate risk assessment that should have been done already under the Health and Safety at Work Act 74 would require life preservers to be there today, just for the fishermen, regardless of whether alcohol be sold. So I wouldn't necessarily think it should be conditioned on the licence, because licence conditions only buy it when alcohol is being sold. So you'd have the daft situation where the life preservers could be taken down when alcohol wasn't being sold, when in fact they should be there all the time. I hope that's helpful.
Thank you very much indeed. Mr. Ranatunga, please continue.
Thank you. Can I just add one final point on that? The section 182 guidance at paragraph 1.16 says you should not duplicate other statutory requirements or other duties or responsibilities placed on an employer or by other legislation. So Mr. Randolph's reference to Health and Safety at Work Act does meet that point, is what I would say. So just in terms of responding to Mr. Banks's points in summing up, if I can deal with it that way, just a few points, if I may, briefly. Firstly, he talks about unknown factors. That is exactly why the Act is set up the way it is. People do have concerns, people do have fears, people have issues about what might happen. The way the Act works is to allow the flexibility, to allow the application to be made, and it is essentially permissive. If and insofar there are problems down the line, what the Act has is a key protection for every resident. A single resident can bring a review application, which brings us back before this committee to answer to it if things don't work. And the issue there is we would hope never to come back before you, because we're quite happy, as we have been, to work with the local community. This is in part for the local community to address their concerns and meet them before we have to go through a review process. Secondly, in relation to, so that applies really to all the fears and unknown factor points that are made. As regards the operating schedule, it is proper to read all of these documents in full. What it says is numbers will be limited to 50 people owing to car parking space. What is the point that's being made is there's a natural regulation through the availability of car parking space and how big it is. It's quite a separate matter to impose a condition on a licensee where no responsible authority is seeking it. Fire have the primary duty, I would submit, to impose capacity limits, and they have not sought one. And the reason for that, and I know Mr. Eaton will know this, and I'm sorry to raise more law, but the guidance at paragraph 10.10 talks about proportionality. Why does it talk about that? It talks about over-regulation being a deterrent to licensed businesses. Because if you do feel it is appropriate and proportionate to impose a capacity limit on a premises such as this, which, as I say, is not an upright bar with door supervisors on it, then someone will have to be charged with counting people in and counting people out. And if we're won over, we will be in breach of a condition which arguably raises a criminal penalty or may lead to a criminal conviction. That is why you don't over-regulate premises such as this, when what they are offering and the size of the building alone shows that it's not going to be significant footfall. And what we've put in this operating schedule is a marker in relation to that as to the capacity in terms of car parking spaces. So it's nothing that's sought by fire, and it's not in our submission appropriate or proportionate to be limiting numbers in that way. The next point that's raised, and just to mention it, is people have problems with the single access track now. I'd ask you, you'll have seen what the residents have actually said. What they raise is concerns about what may happen, what might happen if this business operates in the way they fear. What they have not said is that there's a major issue in terms of traffic now. And so what one comes back to is, what will this add? And with the condition that we've proposed as to deliveries, we say the balance is struck appropriately and there's no need to go beyond that. So in terms of that delivery condition, the point that we're making, what goes behind that, is large vehicles. That's why we've limited the number of deliveries, because it will be a transit van that comes one a day in business hours, Monday to Friday. That's what we're seeking to address through the single access. But you've heard the different types of offer here. One is for the fishermen, two is for people perhaps by appointment, but not necessarily for sampling and buying off sales. But then there is an offer, a third aspect is an offer for people who want to come and have a beer. But ultimately, it is low volume, high quality beer from Lakedown Brewery that's involved. And that's what you and your colleagues still will have to reflect on, that what is the type of activity that's envisaged here? Is it appropriate and proportionate to condition it further than is offered up? And we say that that does deal with the point in terms of deliveries.
Mr. Can I just interrupt? I really apologise for interrupting. It's not normal for me to ask questions, but I'm the person taking notes. When you say low volume, are you talking in terms of the alcohol percentage, or are you talking in terms of the number of pints available?
Number of pints. So it's low volume, not low percentage. Low volume, high quality beer is what we're envisaging, because it's Lakedown Brewery. It's a microbrewery.
Yeah, that's fine.
It's not Heineken or Carling.
Yeah.
Then next, in terms of responses, the hours. So what's said by Mr. Banks is the hours should be limited to dusk, or perhaps an hour beyond that. Part of the reason for having longer hours, as you'll know, is to allow for slower dispersal. That's the whole point of having the flexible hours. That's why we've moved away from 11 o'clock generally in licensing. And in this application, it's 9 o'clock. It wasn't clear to me that Mr. Banks fully understood the hours, if I may say so. Between April and September, it's 9 o'clock for the last sale of alcohol and the last opening. My own, well, you'll form your own views about when it's getting dark at the moment, but the reason for those hours is flexibility, and we've cut back from what we originally applied for in any event. It's 6 o'clock. Last sale of alcohol and opening through the autumn and winter. And then finally, in terms of dark skies policy, that is something we have discussed. We fully support that. We fully support the dark skies policy and the AONB. Both are really planning matters, and the dark skies policy, but it's something we're aware of and we fully support. I see Jamie Daltrey nodding. That is why any external lighting will be kept to a minimum. And will not be something that we say will affect the AONB. It's not something that planning has raised. It's not something that any of the expert bodies have raised. And it would not be appropriate to condition it in the way that Mr. Banks seeks, because conditions have to be precise, and they also have to be proportionate. And simply saying, well, for example, you've got to do a risk assessment and apply it. There are separate mechanisms to deal with that, and that's the way in which those types of conditions should be imposed. It wouldn't be appropriate and proportionate to do it here. As to the additional points which we are prepared to look at, one is the life preservers point, which is condition 1, but you've heard from Mr. Eaton. I'll defer to his legal advice on whether that is something that would duplicate another provision, because it seems to be it would be covered by the health safety. We're prepared to accept it if you did want to impose it, I put it that way, but he makes a valid point that that would then only be a condition which bites on the licence when there's sales of alcohol and wouldn't apply otherwise, unless it was under health and safety. And the other approached residents to discuss their concerns, which has led to the withdrawal of representations. So those are the two from the list from Mr. Banks. In addition, we will offer up a phone number for any resident to contact us if they have any complaints. Jamie Daltrey will do that. There was also mention of signage. On the dispersal point, one thing we can do is erect signage which asks our customers or those who frequented the premises to leave quietly and respect the neighbours in the local area. Quite happy to have signage and a signage condition, which I'm sure your officers will be well familiar with, and you will, on that. And then the last point that was clarified by, I think, Councillor Field is Lake Down Brewery does not sell wine. So our condition is only to sell Lake Down Brewery beer and, of course, non-alcoholic beverages, including non-alcoholic beer. But insofar as there's beer concerned, it's Lake Down Brewery, and that's the only, what the condition says is that's the only beer we'll be selling. If it's not our intention, you know, that's what's clear, it's not our intention to sell wine. Now, there are different views on that, but it's not our, all I can say is it's not our intention to sell wine, and we're limiting it to the local microbrewery that we're seeking to support through this application. So that's the real response to Mr. Banks. So I can very briefly then finally just flag a few points. Firstly, I've mentioned a number of times what the balance of the Act is to permit, in the knowledge that there's strong protections through review. Secondly, responsible authorities. There are no responsible authorities raising concerns here. They are the experts, and all of these detailed matters which have been raised are matters which could have been raised by those responsible authorities if they had a concern, and they don't. Then on residents, of course, we hear what they have to say. We'd ask you to note those in support and what they've said and the content of what they've said as people who've actually used this site over the years and for a long period, as well as, of course, those that oppose and who have withdrawn their representations having spoken to us, and those that remain who are raising concerns, and we don't denigrate those concerns. We just say at this stage, we'd ask you to permit by reference to our conditions, and then see how things play out. And then in terms of conditions more specifically, we've offered those to the police, we've offered those in addition, we've cut back the hours, and then there's the phone number and the signage that we've offered up, as well as conditions 1 and 10 potentially from the list. But you'll take legal advice on those. Proportionality is what the guidance talks about, and we say it is not appropriate or proportionate to go beyond those. And over duplication, or rather duplication, is not something that you should be doing through conditions. So, those really are all of the submissions that I have to make. I'd ask you to reflect really on what the nature of the fishing business is and what is proposed here. It's still going to be a fishing business where noise has to be kept to an absolute minimum. That has always been our intention. It's always been our intention to preserve the land and views. The question is about how we regulate that and whether it's appropriate to regulate it any more than we've done. And in my respectful submission, we've really bent over backwards to accommodate the concerns that have been raised in a way that's consistent with the law. I'll just take final instructions on that, if I may, just if you give me just 30 seconds. Okay, thanks. So unless I can assist you, that's all we have to say.
Thank you. Just for clarification, are you offering the phone number and the WhatsApp group as conditions?
Yes.
Well, yes. Thank you. Unless other councillors have anything to add, I think that probably concludes the hearing. I don't think we're going to be able to give our decision today, so that it would then have to be given in writing within 5 working days. And I think it's probably better for us to say that now rather than to keep you waiting for half an hour or so and then come back and tell you that. So that's acceptable to all, I hope. And thank you to everybody for your contributions. It's been a very interesting hearing, and thank you all. And I shall now close the meeting, and we will cease the recording.